Good evening. This is our APIS Health Angels workshop education session, and our prime focus is on improving the ecosystem for startups in the health, life sciences, wellness space. Our goal is to actually make educated investors, so people who are familiar with the space but need to understand a little bit more of the nuances that are in health, and have the opportunity to have a dialogue and ask some good questions. We're a small, intimate group, and so that's the time to be saying, here's the questions that I'd really like to have understood. I've got a few of my own that I'm ready to ask Ryan about. So our workshops go for another couple of weeks. Then on December 1st, it's the deadline for companies to apply to the APIS Health Angels workshop. And that will be for the January to March period, where investors and company founders meet together on Thursdays and talk about what makes a good company. So we'll be listening to pitches from the companies, we'll be reviewing their guest profile, and we'll be spending some time asking the nuanced questions about how is this likely to work. As we're doing that, we're going to be saving our discussion about is this a good investment deal until a little bit later on, so that we first made the decision on is it a good company. And we're still signing up the rest of our investors. So if you know someone who's interested, and we're signing up the companies, and I'll put the links for both of these in our chat as we go along. I mentioned beforehand it's recorded, and so I'll also put the YouTube channel in for people who want to catch up on some of the previous events. And just make one quick pitch that for next week, we're talking about business models. So while today we're talking about leveraging intellectual property, next week we're going to be talking about what are the different kinds of business models that you could actually have. And obviously, having a licensing play is one of them, but Harold will talk about other strategies that you could have as well. And so I am I'd like to introduce Ryan Buckmaster, who has actually, some of you really know, some may not. Ryan is with the CoMotion program at the university. He has a varied background, and I'm going to actually let him talk about his background. I would say the last couple of things he's been doing he has a new position as the Assistant Director of Innovation Investments, taking over from Jeanette Manis, who has retired, and I hear today has gone off to raise puppies. And so Ryan, Jeanette was a huge asset to the program, and Ryan is going to be is equally so, because he's got great skills. He's got super connections with companies. And I just saw him facilitate the CoMotion evaluations for a number of companies. And he'll have to tell us the date that whoever the winner is will be announced, but it'll be it was a great opportunity to hear all of the life sciences ones and the engineering ones, and know that 7 companies are going to get 50K out of that particular project. I won't brag, but when we finish with our APIS Health Angels, we're actually going to give 200K, but only to one company. So, and so that makes it a harder decision when you get narrowing down to that. All right. So Ryan, may I turn to you? And if you could just take a little bit more time to talk about your background. We'll hear about your what you've done previously and the companies that you're working with now. And I know we won't be able to hear company secrets, but you certainly have some lessons learned from the ones that you've worked with through the mentoring program.
Many lessons learned, many clever ideas come back and haunt me and don't quite turn out like I hope, but live and learn. Yeah, so actually I came from engineering background, material science and chemistry, and as a refugee from the semiconductor industry and a little bit of academia, ended up at CoMotion, which was time was Center for Commercialization, and have the role of innovation development manager, where I worked with the teams often from a very early level. I got this idea, not sure what to do, and probably heard them along the point where then I would play hack lawyer and actually get the license done and get them out, spun out, or to an existing company, or sometimes just help people give things away freely how they want. But a lot was like trying in between idea and be able to actually transact something out of the university. It involved a lot of making decisions about IP, trying to figure out what it was, avoiding unfortunate problems with it. Also, often a lot of pieces of IP themselves are not particularly interesting. IP that protects interesting technology that could be a really great product, well, that's quite interesting. And those things tended to be licensed. Although I'm a big believer in the give me the great team and the mediocre idea any day, because they're usually the ones who will make a go of it. So recently have moved into a new role, I guess a couple months ago, to now oversee our GAP Fund program, the Commotion Innovation GAP Fund. So we may be familiar with over the years, where we give small awards to teams incubating within the university to hopefully get over the ditch of despair along the commercialization journey, and also our mentors programs and other resources such as help with SBIR grants. So very much in the learning phase of the new job, but having fun. Yeah, I guess if ready, I can slide deck. So there's not too many, so like just yell out if you want to ask any questions. Otherwise, I can keep talking and talking. So I certainly welcome questions at any point. Let's see. Let me see if I share that. So mostly I was planning to talk about a little bit about Commotion, if you haven't heard about it, and mostly about IP, to a bit of a basic primer, and some of my viewpoints as someone kind of working to try to get it licensed in many early stage startups or proto startups even, and a bit about agreements licensing, particularly from the university perspective, and if there's some time, we can talk a little about just some thoughts about commercializing technologies from universities and the real reality that we often face. So Commotion, I say, we're basically university's tech transfer office. This has been known by many names over the years. I think originally it was like the Office of Intellectual Property. Then I think it's been through about 6 different names in some ways as it's evolved and grown. For Commotion is the Center for Commercialization. So, before that, there's UW Tech Transfer, and I don't remember before that. Chris might know. But definitely our job is to work with UW innovators, primarily as things that come out of UW research, graduate students and faculty and staff, although we do work with undergraduates to some extent, particularly in education-wise, and to really do what we can to support ideas to have greater impact. And that can take a lot of forms. Commercializations, so the primary one, although certainly social impact and other ways of impact are of interest too. But I'd say definitely in the last decade, a big shift to more and more startups as a preferred vehicle, both out of necessity in many ways, and also a lot more of interest in faculty of being part of a startup and trying to launch it. You would think that there should be lots of things coming out of UW. So that's why we're here, because University of Washington is one of the national leaders in research funding from the federal government. We're usually neck and neck with University of Hopkins and Michigan. I think this might be slightly old, but let's say $1.5 billion, you think that something valuable comes out. And I'd say these days having an active tech transfer office is considered just a requirement to attract good people and make them want to stay. So IP, let's say, very much kind of an overview of what I consider the major types we deal with. Trademarks, indicator of a brand or service. Copyright is an expression of an idea, music, art, software, dance, all sorts of expressive endeavors. Trade secrets, say the kernel secret recipe, Coca-Cola, your Rolodex of sales leads, a lot of business information. When I worked in the semiconductor industry, we very closely guarded our recipes of how things were made and what we used to do it. Save someone a lot of time if they actually knew that. Or chip designs, that's a kind of a hot thing that there's much effort is actually made to reverse those secrets. Patents, kind of probably the most widely known, which is basically a temporary monopoly on an idea. And it's probably one of the biggest spenders in a lot of this, and a lot of most commonly known, probably the most misunderstood. And also it's put in the list that doesn't quite fit in the common legal rights territory, but data is kind of wanted to mention because it's kind of a bit of a new frontier that's opened up where a lot of people wanting data, access to data to make new things, especially with machine learning. That's a of great interest, and especially in the health area, a lot of thorny issues there too. One thing I find interesting about IP is that the cost varies dramatically. Say copyright, actually best for free. If you'd like to register, it's about $30. It's mostly if you want to have a little bit better avenues to sue people for infringement. A lot of copyrights never registered though. So let's say if you're taking notes of this meeting, you're creating copyright. Trademarks, well, you can start to accumulate some trademark rights for free. It's around, $2,000 to $5,000 range per country, so not too bad. Patents, although they're the ones that last least long, and they're also the ones that incur the greatest cost. Being at a university, we often have to make these decisions before we know if there's any actual value, or sometimes often before we know if there's actually the science, this discovery and inventions based on is actually real. We don't know, but for various reasons I'll talk about, we're often forced into starting that process. And it's I'd say to get probably $20,000 to $30,000 to get a single issue patent is a ballpark figure if you're being fairly reasonably economical. And then 20 years from you filing, it's over with, and the world can practice. So, but it's often, the expenses are often incurred far before the value is known. So
And
trademarks, please.
Well, Ryan, who I'm not sure if he can actually hear me. I know he is a lawyer, but I'm not sure whether or not patents or trademarks or anything is something that's part of his bailiwick. So just curious about that.
Yeah, actually, especially for patent law, there's a separate patent bar that could denote expertise. Chris, did you ever pass the patent bar? Yeah, so we have an expert here, probably can answer any minutia questions.
I have been admitted to the patent bar, but I'm here this evening in my capacity as an eager listener.
Yeah, from a university perspective, trademarks are kind of rare because they're rare or not rare. University has a brand, and there's actually an office that does nothing but manage the W and university's various associated trademarks, and they are very jealous about how it's used in their standards and enforcement. And people often ask, like, "Oh, can we use the university trademark for the license?" And it's like, no, I cannot help you with that. But we're all used to these; we're bombarded by them. But just a few little notes. It's nice to see the R symbol circle around it, or the TM. The R symbol means it's registered. You went to the trademark office, and what they do is they look to see if there's any matching trademarks that are too similar, or there could be confusion. So if you, although that's can vary greatly. If you're trying to make something Starbucks, that's an extremely well-known brand, and that's likely be rejected even if you're not doing coffee, is because you're trying to draft off of their brand. Other cases, though, there's multiple brands, like the number of Deltas, Delta Airlines, Delta Faucets, Delta Dental, they all exist separately, and there's not too much confusion. But certainly, it's often a place to start is Google, or look at the U.S. Patent and Trademark Office website to see if someone else is using it, since people often be quite eager to enforce their brand, and the trademark values. Actually, you can lose your trademark if you don't bother to enforce it. The story of Kleenex, Xerox, Google to some extent, brands actually get eroded because they became common usage. So that's something that corporate masters, these brands, pay a lot of attention to. I say there's many things, even the color of fiberglass, which is not naturally pink, that's trademark. If anyone remembers AOL, that was one, you got mail. Trademarks, they have a long, interesting history, which apparently has been pioneered by beer. So, and the oldest ones from Europe. common law and first register marks.
1366, they were protecting the name then. It's pretty progressive.
Yeah. Long history. I say from a university perspective, though, in terms of things we licensed, over a decade, I licensed trademark related IP twice. In both cases, there was actually a product. One was a robotic a surgery research robot that actually had some sales initially through the university. Another was a SaaS software platform, Michelangelo, that I think we had a couple dozen customers of mostly other universities. There's actually was some brand value there. There's been a few other cases. SeaGlider might be one of the bigger successes of the automated data collecting robots, but DIDB, a well-known database in the pharmaceutical industry, and a few others. But probably, I say, it's not really our forte. But even if you are a startup, there's a lot of basic tips, like check if it's actually in use, because people will find you and demand you cease and desist. In fact, if you want to protect your trademark, you're kind of obligated to do so. Another rule of trademark, if it's very descriptive, then it's not, it's a very weak mark and it's hard to protect. The weirder it is and the more strange it is, like Google was initially a great trademark because what's a Google? Yeah, the number naming has nothing to do with searching, although it's now it obviously means search. But if you were making like a muscle strength conditioner and that was your trademark, you may not be able to get it and be very weak. Yeah, say if you do have a brand, the easiest way to start for free, which is great, is just put a TM on it, and it starts. Let people know that, hey, this is my mark. I'm trying to build up the brand, and maybe later you can register it. Although hopefully you checked in the beginning. But nice thing about the trademark though is if you're a startup, probably people don't know your brand very much anyway in the early days, so it's not a lot of cost just to ditch it. Let's say in the UW innovation ecosystem, we've had a number of interesting trademark disputes. This one actually wasn't a university one, but it was local in town of a kind of a pointless lawsuit between two marinas, spelled slightly different, who people actually got confused between them. And after spending a bunch of money, they realized it's kind of stupid since it's changed their name. I say it's probably pretty poor use of money for a startup, I would think. Mm-hmm. There was a team at University of Washington, speaking of mega brands, that they had a cool technology. I think Chris worked on at one point to literally roll kidney stones out. And they want to call themselves the Rolling Stones. In spite rolling kidney stones having nothing to do with magazines or rock bands, that was politely denied by the copyright holder. And it's probably a famous enough brand that everyone gets the joke. So hard to do. And we occasionally also have startups at UW that get threatening letters, and usually it's easiest to change the name. It happens, but if your startup's mostly a conceptual idea and there's 3 people and no one's actually even drawing a paycheck from the startup, just change the name. Right.
So in the trademark, could I just ask a quick question? Like you mentioned Google, and is Google's trademark, is it the name only, or the fact that it actually has that multicolor rainbow logo?
Yeah, that's a good question. So it's both. It's the name itself, and it's also the kind of design flourishes around it. There's some other odd example, like the Coke bottle shape, the old glass Coke bottle shape. That was a trade dress, like Shell gas stations, kind of a collection of branding items. How they do is kind of similarly protected. Yeah, sometimes, the very color, sounds, and those sorts of things can also be protected. So
I just wondered if it fit under trademark or one of the other of the.
I think it's under trademark.
Okay.
This is a whole area of law that's to itself. Mm-hmm. That I think you can also find endless fascinating disputes of.
Thank you.
Yeah, copyright in some ways was my favorite just because there's so many strange ways it pops up and nuance of it. But it's really a form of expression. It's not actually of the idea, but how you express the idea. So for example, if you would like to write a book about a wizarding school in Seattle as they battle gloomy skies and bad traffic, you are welcome to do that. You probably would get in trouble if you had various heroes called them Harry and called it Bogwarts and kind of paralleled J.K. Rowling's work, you'd probably get a letter from her lawyers to cease and desist, unless you argue it's sarcasm or something. But that's kind of the challenge. Like, so for more technical, anyone can write a software that has a specific set of functions, as long as you don't derive it from the original party's work. So there's actually some kind of really archaic terms that appear in the copyright that we use in software. It's kind of interesting. You'll hear like right to reproduce, for derivative works, distribute, perform, which is often like play a videotape or run a computer program, or display, which that probably meant originally like a poster, but now we might think of something flashing onto a screen. So it's a very old law that's been adapted and updated to deal with new forms of copyright that arise. Yeah, as I mentioned, it's about the form of expression, not the subject matter. Anyone can go and do general subject matters. This is an area of endless disputes. Recently, there was a big lawsuit of around tardigrades about recent Star Trek series apparently featured tardigrades in space, and someone else had written about them in some science fiction book a number of years before that. But that was saying that just because you happen to have the similar things, you didn't obviously rip someone off, that they can still use bugs in space as they like. So university, I say all sorts of things are copyrighted. We've had games, structured databases, videos, advanced videos, a lot of educational materials, and some of those are the basis of startups. But the biggest one's probably code, of various sorts and various quality. But and that's often because commercial interest. Code from the university perspective is interesting in that at the time it's licensed, it has a lot of value because it's something. It's beginning. You can do often some initial customer pilots and things, but also most university code is not commercial quality for the most part, unless it's developed by a business unit to accomplish some sort of administrative task or some very rare research laboratories. So usually it gets quickly rewritten, and eventually it's hard to really see the connections of the original code, although it is derived, and that's often a debate of how long is that code actually what you licensed, and should you owe royalties. So I have a little test for everyone about copyright, since we learned everything we need to know. This was an infringement case about a New Yorker cover here, which alleged that this Robin Williams movie that I don't think any of us have ever seen said that they ripped off their idea. So who thinks there's a copyright infringement here? Anybody? You want to yell out yay? No?
Nay.
Just a bunch of greedy lawyers. Actually, it was ruled as a copyright infringement. So if you kind of look at various elements, so look at the kind of font between the poster and the magazine, the way it's kind of the myopic view of the rest of the world from New York, the shadows of the building, the style of the writing. It's kind of often a bit of an accumulation of evidence that kind of ruled that there's really no sharp line, but that went from paying homage to basically copying. And I think that was settled with some money. Another big lessons of copyright is it's often, especially in the digital world, easy to find. You Google search and do it and can grab it. You should make sure you have permissions. So this is a painful lesson from the U.S. Postal Service, which thought, oh, this nice picture, the Statue of Liberty, which if it was just a picture of the Statue of Liberty is now in the public domain, or they could hire their own photographer. But this is a Statue of Liberty from Las Vegas, which was actually not the Statue of Liberty, but in fact, it was an interpretation of the Statue of Liberty, resembled off the sculptor's mother, actually. And so that was a rather expensive lesson to the United States Post Office, which doesn't usually pay licensing fees to use images. So it's always good to check before you do. There's another area of rife dispute. Even open source code, often, there's conditions if you don't meet that. There's various groups that will sue you to rectify that or stop using it. Oh yeah, so there's comparison. You can see that that was not the Statue of Liberty. Your diligence lesson there. Yeah, in copyright, mean, there's a lot of places to get tripped up. In our licensing of copyright to early stage companies, we actually review everything to make sure there's not third-party rights, that we actually own what we're licensing, because it is so easy to accumulate. A lot of research projects, people don't think about it. So third-party rights is a huge one. Various permissions, snippets of code, other medium or things that you find. Some cases people think, oh, it's open source, so I'm fine. That's a huge area of, I say, of caution. Open source does not necessarily mean truly open source. There are some licenses, MIT, BSD, or popular ones, which are basically do whatever you want. I think you just maybe acknowledgement, but you can take that. Actually, the iOS in Macs is from an open source project, BSD, which basically allowed them to take it. They don't have to share their changes with anyone. But other ones like GPL licenses that you have to actually provide the source code of any changes you made to the project. You can take it and use it, you can sell it, but you have to provide source code as well. People still build businesses around that. Also, some of those licenses include patent licenses, so you can inadvertently grant licenses to your patents or create ownership questions. And also, increasingly open source projects have commercial use limitations. A lot of them are aimed at like Amazon and cloud providers like AWS to prevent them from basically taking the project and offering a service. But there's also many others that there's some sort of monetization that you can get the source code, you have it all, but if you actually want to use it for commercial purposes, you need to get a commercial license or such things. Universities as well sometimes do that. That's like free for research purposes for people to share with their fellow researchers, but the moment you're trying to make money, you just come talk to the tech transfer office. So usually these details are in a file in the distribution that's a couple paragraphs long, sometimes longer, but it should be there. And I say certainly can't have expensive commercial implications to fix things or have that come up. I say trying to close an acquisition, having that come up that you have problems with your code is probably not a very fun time to discover that.
Hey Ryan.
Yeah.
A quick question on. I mean, I think copyright's become really important with software because have the laws changed over the years with what you can patent around software? And so, I mean, you definitely copyright it, but you can't always patent your software, your algorithms. You can patent algorithms, right? But not like the software code itself.
No, yeah, sometimes you can, that's actually a really active area people are trying to figure out. I think about the case with Alice actually deeply reduced the ability to copyright around certain types of software activity. Like basically you can't copyright, you can't patent human activity anymore. But now it's been shifted, so it's more abstract patents around software become extremely difficult. Actually, I did have a case where I had licensed something that was around organizing people to crowdsourcing, and right after we licensed, that case came out, and by the time it came up for examination, it was hopeless. People then shifted more towards trying to tie it into the machine. Seems to be a strategy, like, we're running this algorithm and this is how it's interfacing the sensor system, or this, you're changing the data in this way, relating to how the computer works. It's gotten more specific, but kind of the broad business type patents, certainly harder, and also a lot easier mechanisms to invalidate them for a lot lower cost. People still try. I say Google still files a lot. I think it's a lot more defensive, and also with software, it evolves quickly. So maybe you've kind of patented something around an algorithm, but your next version is different enough that it doesn't really matter, and you spent $10,000, $15,000 in the application, and it's not important anymore. That's also a risk. That's what I say. There's been some software patents that have been incredibly lucrative, like some early encryption patents that was the standard, so everyone did it. But this is definitely an active area, although it's definitely court rulings have restricted that quite a bit. And also I say something to be aware of. This is probably definitely a startup 101 type thing, but say make sure that your employment contracts and your contracting agreements are up to snuff, because if you don't, usually ownership of inventions and copyright and things will accrue with the person who did the work. So you could hire someone to write all your code and you don't actually own it if you don't bother contractually stipulating that. So that's something that could be a very costly mistake. So trade secrets is probably the area that I didn't, from a university, we don't tend to deal with because basically our MO is that we're trying to disseminate more knowledge. Also, public records law made some real constraints about keeping things secret. In the rest of the world, there's this trade secrets is just kind of part of reality, and every business has endless number of them. I think Washington State University will do a trade secret deal, and I'm not quite sure how they legally arranged it. But they literally had very tight access to the data. A different set of people actually doing that work was very limited. Probably like the company actually owned the data and trade secrets aspects. So, but probably something that you wouldn't really see from a university. Thing is that it's up to you to keep it secret. If you don't keep it secret, or if it gets out anyway, that's kind of too bad. You can seek some remedy, but once the information's out there, it's too late. That said, this is an area of endless litigation. So the recipes, formulas, list, know-how, kind of an often term bandied around. Sometimes it's anything that's not a patent, but often more tightly can be used as trade secrets. This is an area where it gets expensive. Employees tend to be a case of when they go from one place to a closely related new job. They say Alphabet and Waymo had a very expensive dispute that was Google had to pony up $245 million to solve to remedy, as one of the engineers from Alphabet from Waymo took a bunch of apparently confidential information and documents and secrets. Apparently also someone wanted to steal the recipe for Bud Light. Personally, I didn't know that was a desired thing, but if you're a Bud Light fan, know that it was stopped in time to keep them making Bud Light knockoffs. But a lot of issues. Often it comes out from where someone was given information and then they can't prove they didn't give it to other people. Joint development agreements, or sometimes confidentiality agreements can be. I say generally say you probably don't really want to know someone's trade secrets unless you absolutely need to know them, just because it can get messy. University, one thing we always strike from confidentiality agreements from receiving information companies is trade secrets, because we can't make university professors promise they'll never speak of something ever. But it's a pretty common thing to have in confidentiality agreement, but you probably shouldn't tell anyone something you don't want them to know. And briefly, let's touch on data, since we're seeing a lot of interest in data, mostly as an input into artificial intelligence, machine learning, and data mining, and particularly in the health area, things like taking health records, outcomes data, for a lot of kind of smart systems to help to make recommendations. It's become a hot area. Also, a lot of biology drug development tools, more and more I'm seeing like that data component to it. Like there's some sort of new assay, unique data, and a lot of them seem to be marrying it to machine learning platforms, try to get additional insights out of it. But definitely say there's a lot of complicated issues, often permissions of data, especially medical data consent. There's a lot of data that probably cannot be used for commercial purposes, because when they collected from people weren't asked to consent to be used for commercial purposes. Of course, privacy, identifiable data has become a big thing. Also for public institutions, public use. Probably a lot of universities where like large data sets, a lot of them probably would not license it exclusively to one party. There's been some cases, some institutions were faced a lot of criticism where a data set accumulated over 30 years was licensed exclusively to one startup, and questioning, is that really in the public interest, and who's actually profiting from this long body of work? That's increasingly coming up. And also there's a lot of regulations over data, certainly HIPAA for medical data, but also private, various things like the European privacy laws and others, financial data a long time. For licensing, it's kind of a bit of a frontier issue that we're seeing more and more interest in. At the same time, a lot of thorny questions that, how do you value it? what is, is it a percentage of sales of the money made from the machine learning model software comes out? Is it a one-time thing, or, how does that? It's a lot of questions that people are trying to figure out. So just kind of point out that's certainly something that we're trying to have to deal with. That came up more and more. I think it's only kind of bigger issue.
Could I ask a question? But
yeah, please.
Going back to the slide there, please. Thank you. So the issues around permission and consent, privacy. So if you use an app and we are collecting data, and it's a wellness app or a medical data. So wellness app, very generalized data. Medical data is very particular or personalized. How do we get the consent, and is an end user license agreement good enough, or is that something that we had to be explicit about?
So I say it's probably something that's an attorney question. I'd say that my understanding is it has to be pretty explicit about it. That there's cases where there's only like one source of data. Sometimes is biopsy samples generated from people, and if someone did not explicitly say they're okay with it being used for commercial purposes, and you simply cannot. We've seen that pop up quite a bit. So I say it's often a lot of what degree of consent probably kind of depends on the just how much you're collecting, whether it's just kind of metadata from use, or if you're starting to collect medical records and things, it gets a lot more complicated. And also who owns and can give permission for those records. Yeah, it's probably something definitely attorney in the area I would definitely ask.
That's fine. Thanks.
Okay. So next is patents. Oh, yeah, please.
I was just going to say there's many other areas about data. For example, your x-rays or your brain scans or your cellular genetic makeup. Everyone knows the immortal cells of Mrs. Gratwick's, that was taken for samples and then multiplied numerous times in terms of genetic makeups.
Yeah. Also, I think a lot of people realize that they have consented to, the heredity DNA, services. Like, oh, I'm related to Genghis Khan. Well, you've also they have your sequence there that's increasingly mined for medical research and development, which I think a lot of people didn't quite know that's the whole deal. Definitely an interesting area of where the bounds are.
Thank you.
Thank you.
Yeah, so patents is interesting. It's probably an area that it costs the most money and spent the most time, and in some ways has the most uncertain value. But for some things, you absolutely need to have them. Other areas, it's maybe kind of a nice to have. In some cases, it might just be is it really the best use of resources? So I think it's very situational. One thing is this big misunderstanding of patents is it's not actually a positive permission. It's not an affirmative right. It just simply gives you the right to sue people, make them stop doing whatever is covered in the patent. That some people might want to get permission rather than risking you serving them, but there's nothing that. But I say it does seem useful. I mean, it does establish some ownership of invention. Create value. Also in the fact that it is something that's been vetted, that if you actually got a patent issued, or you convinced the University Tech Transfer Office to file a full patent, that maybe there's something there, something unique. So that can be a bit of a signal. And I'd say probably where patents work best, in my opinion, is when it's a very concrete thing that can be described. Molecular arrangements of molecules, physical devices, cases where it takes a large input of resources before you can get to market. Patents seem to work pretty well. I think where there's a lot more debate is things like software or small components of bigger systems. And there's some, it's kind of a long debate of like, or in such cases, if you're enforcing your patent rights, are you merely seeking what your own due is, or are you actually basically being a troll and trying to seek value that's not yours? one tiny part of the iPhone, what's that worth? That's a vigorous debate. I'd say that recently the law has gone on a bit more of the against patent owners. It's a lot easier to validate patents than it was before. There's a lot more avenues to do that. I think there's court decisions have winnowed down the areas that scope of things that can be patented. So you can't patent drug targets anymore. Organizing human activity. A lot of just general processes around people can't be done. So that's certainly a big challenge. So what is patentable? In theory, anything under the sun people make. So if you find something that's naturally existing, that's not patentable. But if you've made it or altered it, in the life sciences, there's some significant changes of, if you just look at some genetic code, actually around the breast cancer genes, there's well-known family patents. Is it ruled that just looking at that code is not actually worth a patent because that's a natural thing that exists. Taking that genetic code, changing it in a different way that then allows you to read it, that is patentable. And that was actually the process was done to go from DNA to cDNA and then actually read that. But in and of itself, that things are known aren't. Many things can't. Say the more abstract you get, more likely you're not going to get the patent. And I think I mentioned the patent rights. I say it's definitely from the IP holder's point of view, it is a lot weaker than, say, 20 years ago. But as the university's large research institution, we get a lot of different things that are patented. Certainly, say, therapeutics, that is kind of a booming area. Researchers such as David Baker Institute Protein Design of novel molecules and protein structures. We've actually had a patent on a musical part. So apparently most people thought that was rather impossible. Everything in musical instruments has been done already, but we proved them wrong. It was not a commercial success, but can't win them all. Chemical compounds of different sorts, materials, those patent very well. Medical devices, there's a lot of people at the university like to do medical devices. There's also medical devices an area just because of the, to usually get regulatory approval that, you need some good IP protection. Otherwise, by the time you show everyone this is a great idea, they could just copy you without having to make the massive upfront investment. Same thing with therapeutics, where that is important. Methods, although often that's seen as weaker since it's harder to find someone practicing your method and it's easier to get around it, just change your, if you can take out a step, you don't need to infringe anymore. So all sorts of things there. I say probably things that relate to health, though, probably mostly see therapeutic compounds, like diagnostic methods, related compounds, in devices of various sorts. That's it. Here's an example of a fine patent of a very important product that managed to get the stamp of approval of the patent office. Dark ear protectors. But so there's a couple elements of an invention. This often comes up, university researchers, who gets to be on the patent. And me too, both. And one is conception, that's thinking up the idea, or at least an element of the idea. These often are kind of distilled into the patent claims, what's actually covered. The other is reduction to practice. Even if reduction to practice is really hard, that doesn't make you an inventor. You don't get listed on the patent for that. So you could do, there's not a whole lot of credit given by the US Patent Office for implementation. It's more coming up with the idea is the valuable part. But that, though, who's the inventor doesn't matter. If you have the wrong inventors, you knowingly left someone off, that can be a grounds to invalidate the patent. So often, especially in the university environment, common people like on papers to put people who are supportive or helpful, or you have to put on there for whatever reason. That is a bad recipe for patenting, because they didn't invent it, they shouldn't be on there no matter how important they are. So that's often a lot of education we have to do, and occasional areas of dispute of who was an inventor or who wasn't. But that's usually comes down to the patent attorney to help try to suss it out. Did they contribute to coming up with the idea or not? The patent office does have a handy set of criteria. mean, the first one has to be new and novel. Usually for stuff out of the university, this doesn't come up too much. A lot of stuff by inherently people research new stuff, so we don't tend to run into that. Although I did have a research group that came up with a medical device they thought was needed. We found a patent from 5 years ago that covered every single idea element they had, which is sad because it's sitting on a shelf and was actually impeding. Useful doesn't tend to come up so much. I think there was once a court case, someone who actually managed to patent making trash bags of faces of jack-o'-lanterns on it, and was rejected for that, but it's determined actually on appeal that since they are selling commercially, it must be useful, even if frivolous. Non-obvious, this is probably comes up the most, where the patent office is basically allowed to go cherry pick pieces of other inventions and reassemble yours. So if you imagine patenting a car, you might have wheels, you have a drive shaft, you have some sort of steering apparatus, and in the world maybe the car hadn't been invented yet. You made the patent office find the motor. I mean, that's one of your key claims that's used to turn a belt in an industry thing. Well, they found a cart. Those are wheels. For steering, they found some sort of gear assembly, and they say like, oh, these are all pieces known. It's obvious that anyone would see you put these together. So that tends to be a place where most arguments come from. That and probably a subject matter eligibility for things that are software. And then you have to have enough detail to actually describe it. The theory is that in exchange for your limited monopoly for well, you get less than 20 years, but for that period of time, you need to tell people how you did it. So when your patent expires, you have then effectively put it into the public domain. So then people can use it, can then benefit at large from that without restriction. But things that come up a lot.
Question?
Oh, yes, please.
Sorry. So if you were to use open source code and you come up with a non-obvious method of computing something in software, is that patentable? Or if we did patent that, do we have to put it back into open source code right away, the code itself?
So I think that's a good question. I think there's two issues. I mean, one is you took the code and you kind of distilled that into a process without making changes. The patent office might say like, that's already been invented. You're just writing up someone else's invention. You took the open source code and you modified it to something different, and you found some new way, as a new process or some new way to choose through the data or whatever. You can certainly
use it to apply to something else. Sorry, yeah.
Yeah, so there needs to be something new from it, or else it's
right.
Like you say, like physical invention, things are already known, but if you added another feature to it or modified it in some way that was different. Another thing would be open source licenses, like some things like Apache and GPL, where they include a patent license to any related patent. So you would have effectively open sourced your patent by accident, or unless that was intended. You certainly, big companies like IBM which have put a lot of things open source, they were quite careful of what they did and didn't do. So, but for the purposes of getting a patent, the idea of the system is that you have something new and novel that no one's done before.
But there's no, right, okay. Okay, thanks.
Ryan, there's a question about software patents. Does it really make sense to do software patents? All software people seem to think that all software is obvious.
Well, you can sometimes get them. I think it's debatable. I mean, I kind of look at the lens of, is it really worth spending $20,000 or $30,000 on that and something else? And also how quickly you're going to change. I mean, there's cases, I think, if you had something truly fundamental that became a standard, it would be a powerful moat and protection. I guess money's no object. Yeah, why not? But I often kind of question just because how long is it going to be before you kind of moved on to the next thing, or someone could work around it. That's often a good function that, you have this way of doing it, but a good test might be, ask people like, so you got your patent, how easily could you, if I gave you the time, work around and find a way to get around your own idea? I'd say it's debatable. mean, we did have a large FANG that acquired a startup, and they could care less about the patents. They just wanted a non-exclusive license, so that it didn't bother them. They saw no strategic value of it. I'd say like a lot of AI stuff, that probably the data models and implementations and customers a lot more valuable than patents. But it's nice to have if most people seem happy to see them, although I often question how valuable they really are. We debate that constantly. It's also hard to find infringement. It's also easy to get around it, because if you break up the process in two different places, like one on a local machine and one on like a server, that in some cases can overcome infringement. So it's very debatable.
Okay, thank you. Because that's one of the big things that the investors are always asking, what's the moat around what you're doing?
Yeah, often you find, even though for more traditional patented items, they seem being very early in the funnel. Sometimes also the molecule evolves over time. That's for the drug, or the device changes, and the original patents don't matter in the end. But that's the game. You gotta take some shots.
Thank you, Ryan.
Yeah, a couple pieces of terminology that come up a lot. I think often get misused a lot. One is patentability. That's just really can you get a patent, which is a necessary but not sufficient condition. That's just satisfying the patent office that getting through their criteria, the patent examiner, and it's somewhat related to that. Is that can you get something that's broadly enough patented? Because there's often a case where if you persist long enough, you'll find some minor variation that they'll give it to you. But if it's trivial to get around, or it doesn't really protect anything that's important, then you got your patent, but it's kind of meaningless. Just negative values, time and money you spent on it. But patentability really is those criteria you talked about, and also caution here that your own activities, can impact your patentability, which we'll talk about. I've had researchers who gave a talk, and a year and a week after they gave the talk, they told me a company was interested in what they did and wanted to know if we could file a patent, and it was too late by a week. So you can cause yourself great pain, and also your previous patents are also fair game for the patent office to hold you to it, to deny you a patent or narrow it down. The harder one is a freedom to operate. So some cases like there are some cases where there's well-known broad patents out there. Like there used to be one in microneedles, I think recently expired, that was really, really broad, that basically if you wanted to practice, you have to go get a license from the university that held it. So it's harder often sometimes to know, though, because freedom to operate could be that there's a small little subcomponent within your device that's actually the element where you run afoul of. That's not something you necessarily look for. I think software is really hard to know if you're ever truly free of infringement risk. But it's an area where those analysis can get extremely expensive. It's everyone wants to know, like, are you safe? Like at some level, Google and searching at USPTO website, Google patent can give you some clue if there's anything close, and an attorney can help you decipher those. But there's always a kind of a risk of something from left field, and people always ask. And I think the university's policy is that we make no promises. That it's very much the business using the IPs need to figure out. But freedom to operate, it's hard to know for sure. Let's see, so public disclosure, also known as how to lose your patent rights. It pops up constantly. I think probably most businesses are a little bit better on this element than a university is, because university people are paid to go talk about what they did. But public disclosure is basically you reveal your invention some way. And the US is very kind in this respect, and that gives you a year after you've done that to still file a patent. So if you were that researcher and they had contacted me a couple of weeks before, we could possibly file a patent and still had a US patent. Much of the world, though, it's too late. Too bad, so sad. You have you have donated to the world the moment you publicly make it known. Europe's like that. Most of the world's like that. I think some exceptions, Australia and Japan, I think have 6 months or a year grace period. The United States is very kind to inventors in that respect, but public disclosure, though, it comes out in a lot of places, often where people don't think it matters. Obviously, like printed publications, initially in patent laws put down as like, putting something in a magazine or journal. Now, you put it on the internet that's publicly accessible. There's no password. Well, even if no one comes and looks at it, it's public disclosure. And that actually was dredged out by a lawsuit. A licensee and their competitor were in a big lawsuit, and the competing company was trying to challenge the patents for all sorts of reasons. And they managed to drag out some evidence that some undergraduate students put it on their personal web page. So stuff can come back and haunt you in a lot of ways. Even basically, if it's not a private, and oral communications also count. If it's not a private gathering with a explicit expectation of confidentiality, then it could be a public disclosure. So in talking to IP attorneys, I can never quite get a 100% clear answer. It's just increasing levels of discomfort. But in those cases, a way to actually avoid that if you're having a meeting via a confidentiality agreement. Because even if you're just talking to an individual, say if you had an invention of airplanes, you're talking to Chris and Jeanette, well, you're talking to some deep connections to the airplane industry, especially technical people, that could be considered a public disclosure. Also, not so much, doesn't really typically appear in the university, but say offers to sale, that will start the clock ticking or lose rights. But definitely, I say these are sorts of things you want to manage. Sometimes questions come up because a lot of investors are not too eager early on to do confidentiality agreements. I mean, my advice to a lot of early startups and research teams is, you don't need to talk about your secret sauce day one. You talk about what you do and why it matters and those sorts of things. Then you need to go deeper into actual confidentiality aspects. Also, from the university side, that we file what's called provisional patents all the time, which are much lower in cost. You can actually, much even had undergraduate students figure out how to do it themselves, but on the order of a couple $1,000s, you can get those done. And it's kind of quick and dirty and kind of saves your, avoids the losing rights over public disclosure and gives you a year to decide if you want to spend the $10,000 or $20,000 to actually draft the full patent. So that's a common thing. Although generally, I found that patents were kind of at war between filing sooner, because you want someone else to get there first, because the US is the first to file. Everywhere in the world, first to file gets the credit. But the longer you wait, the more certain you are, and the more you're actually pursuing something that matters. I find that usually filing on things that don't matter is higher risk than someone beating you to it. But there's exceptions. We've occasionally gotten killed because someone published their paper similarly a couple of weeks before the patent was filed. A lot of categories. Usually utility patents is the important one. That's any sort of process or machine or composition matter. Plant patents, that's a pretty niche area. Design patents, you'll often kind of see, kind of follow tech news at all. Often, like, for a long time, there used to be like this, like Apple and Samsung were battling out, and they were design patents of like really kind of the proportion of the phone and the screen, kind of those elements. Design patents are also pretty common, like automotive ways, technologies, but they're really just about design. Don't file too many of those in the university. Startups, occasionally, I guess we've seen places where they could be useful if the ergonomics really made the utility of the device, but usually if I see utility patents 99% of the time. Let's see, I mentioned some of this. So for your expenditure of tens of thousands of dollars, what do you get? So the patent term is 20 years from the date of filing. However, you can't actually enforce your patent until it's issued, which will usually takes 3 or 4 years at least, potentially longer. So you maybe have 15 years of having a full on useful patent. Foreign rules, they vary a bit, but they're usually all about 20 years of patent life from the date of filing. And after 20 years, your patent lapses. And there's certainly industries where people eagerly awaiting. Intuitive Surgical has a very, very big patent portfolio. And a lot of their key patents around surgical robotics are steadily expiring, which is probably why you're seeing new entrants into that space, because people are kind of waiting until there's no longer such bad freedom to operate issues. But a lot of technologies of the whole 20 years, people have moved on before then. But sometimes, I say, there's things that are just really valuable and they try to milk it. So there's several parts to patent. You'll see a title page between the inventors and also who's it assigned to. Recently, there's been some changes to the law to make that a bit more clear, probably in response to patent trolls, who actually owns the patent. Brief abstract, there's some background of like what the problem is they're solving, summary of the invention, but the part you really care about is the end of the claims. And that is actually the part that if you practice without permission, that someone could come sue you, you stop and try to get damages. That's really what you argue with the patent office over, is what those claims will be. Usually it's a process of the patent office casting doubt that you deserve such big claims, and you're trying to make them more narrow or more conditions till finally you reach a point where they're happy. Although whether that's still valuable is the $30,000 question. But here is a very valuable patent. This was filed by University of Washington and was a method of making very useful biological agents out of yeast by Ben Hall, who actually has a building named on the campus. And this brought many hundreds of millions of dollars. It also, you see this is claim 1. Generally, the claim this long is probably a red flag, because if you hold up your hand, it's probably longer than your hand. Because if you didn't have to do step C, you could get around that somehow, you could get around the claim. But actually, though, apparently there wasn't actually a better way to do this. And so this was a very popular way for various vaccines and biological agent compounds to make. And a large number of non-exclusive licenses were done on the technology. Mostly the Washington Research Foundation primarily managed that patent. And so it was the university's big win. But sadly enough, it expired, and as things do happen. But so you
Was that about 2 or 3 years ago?
I think maybe about 5 years ago.
Oh, yeah. Okay.
Yeah, it corresponded to budget cuts and all sorts of things.
I guess the time's flying. I remember.
Yeah, it's most universities are in the case they actually make a significant amount of money. That is probably for 1 or 2 patents that carry the bulk of the weight.
Mm-hmm.
But if you do want to get a patent, so as you file your patent application, and you've spent probably at least $10,000 to have it done well. The sky's the limit, though. You can easily spend $100,000. The attorney will be happy to indulge you. Let's say $10,000 to $15,000 is probably a good benchmark for a competent attorney, depending on how complex it is. Then you wait. And the patent office recently has gone faster. It used to be more like 4 years. Now, sometimes even actually less than a year I've seen it, but usually around 2 years. The patent examiner will look at it, and sometimes they'll want you to fix a few things to start, but then they'll usually give you it's called office action. They'll look at it, they'll find some other sources, and they will typically, the joke is all claims rejected, doing well. Their patent examiner's job is to try to make sure you really deserve what you get. As I said, the patent office, it's a system. Is it a fair system? No, it is a system. But I think they do sincerely try. And that goes back and forth. Usually you have an attorney do this for you. For the privilege of that, that's probably between $2,000 to $5,000 each time back and forth. So that gets expensive, but hopefully you'll be able to address the issues, and if you're lucky, then you hopefully after 2, maybe 3 times back and forth, you've gotten to the point where the patent office agrees you can get some claims and it gets issued. But it's not going well. You can, as long as you want to keep spending money, keep on trying to convince the patent office. You can then, after their final rejection, you can ask to keep on doing it, usually, and keep on arguing until I guess you run out of your 20 years. So the patent office does run on, if you want to keep on spending money, they're happy to indulge you. But generally I'd say, yeah, 2 to 4 years is these days pretty typical to get to issuance. You can then continue to file on what's called continuations to get more claims. You're basically, though, you are confined to the content of that document you submitted is what you can potentially make patent claims from. So if you have new things since then, you need to file a new patent. You can't. Well, there's some, generally, except for some minor exceptions, if you've found a way to make your invention even better later, you file a new patent that, which is, of course, a whole new set of expenses. So I'd say it's kind of a long, expensive, grueling process in the end, and there's no guarantees that you're gonna get anything useful out of it. A lot of patents are just abandoned because of say patent office sometimes finds prior art, where it shows it's not novel, or obvious objections you can't get around. Court cases could happen that restrict patentability. There's no redress any of that. And if you even get here, it's no guarantee because there's numerous cases where infringer could challenge your patent and try to invalidate it. So, which is in some ways a good sign because it means you actually have something someone cares about. If someone doesn't care about your patent, they're not going to try and invalidate it, but it's expensive. So you got your patent, congratulations. So what do you do with it? There's all sorts of fantastic companies that offer products to make your patents into lampshades, plaques, and coffee mugs. That's certainly a thing you can do, put on your resume, on your CV. Lots of people like to do that, but that's not really the purpose. One is you can threaten infringement suits. Your cease and desist letters are a whole lot more credible if you actually have an issued patent. If you have a pending patent, you can still suggest people should take a license where you will sue them as soon as you can. But a lot of things are licensed before patents are issued because of that very reason, to have predictability. But certainly it backs up your threats. However, if you threaten someone with infringement, they can also then take you to court to try and validate your patent to claim that they're not forcing you to respond to them, or else they get a default judgment and you can't sue them anymore. So there's hazards of enforcing your IP. Certainly you can file infringement suits. This is extremely expensive. So universities are generally reluctant, some more than others. University of Washington has filed infringement suit in the past. It was an expensive learning opportunity, but the company didn't really retaliate, but they did invalidate the patent. Other cases, some companies have retaliated. Between companies, infringement suits are not too unusual. But typically what will happen in the infringement suit, the early stages, the accused infringer will try to invalidate the patent, which is expensive. This is like hundreds of thousands of dollars or more, even just to get going. So, although there's, there are companies that will do speculative litigation. Usually they take half of the money made after their expenses if they believe there's a big case. So, but I say that is a way you can get top-notch lawyers. There's a mechanism, but I say for a startup, if you're caught up in an infringement battle, you don't have deep pockets. It's expensive, although it does come up occasionally. As more common though is that the patent is licensed or sold. Basically, you're giving someone else a "don't get sued" card. Whether you want to license or sell the patent, I think that depends on your preference of control and what your business model is. The universities almost always just license. They don't like to sell, but all sorts of companies, they'll often sell patents for various reasons. So my top 3 patent things is manage public disclosures, loose lips, create bar dates, and lose IP rights. So that is probably easier to tell the commercial audience than a university audience, which universities are encouraged to tell everyone what they do. But you can't get it back once you've done it. There's no way to fix it once you've disclosed something. Also say patents are not everything. Say a patent, a lone patent that's just a patent without some sort of technology around it or evidence product usually doesn't have a lot of value. I mean, sometimes you get lucky, file a patent, and someone else does it and makes it valuable, and you can try to coax licensing or infringement suits. But usually patents, they're valuable because it covers something people want, a product. The more there's definitely licensing, the more things are developed, the more likely it's going to go out in the startup or be licensed or something. A lot of patents, they come and die and no one ever notices them. Also, I say there's lots of other obligations where you accidentally give people licenses. I see these pop up in all sorts of weird places. Purchasing agreements sometimes, like if that's with someone's machine, or anyway, you give them a license to anything you discover. Some of those severe development agreements, if you're dealing with a large company, you should get an attorney to help you through that. There are many large companies that enter development agreements, startups, and didn't pan out, but they left the startup crippled due to IP complexities, and Fortune 500 company doesn't care. Also, sometimes they've also seen patent language in NDAs, like if I tell you my idea and you somehow use it, you need to give me a license. So things pop up in weird places, which means you should always look at the fine print. So yeah, any questions? So just a little bit about, probably everyone here knows plenty about non-disclosure agreements. This is probably an area that's most standardized. Most of them are not too unusual. That said, still sometimes weird things pop up in them. Certainly for anyone receiving information, I'd really kind of think of, do you want to know their secrets and which ones are they, and how long do you want to keep the secrets? Do you really want to keep it forever? Since there certainly is litigation and what's done with things. I think we mentioned this a little bit. Say one good point for any sort of assignment or transfer of intellectual property agreement, especially patents, is that the person who's an inventor helps later in the future, which they might have moved on to another place of employment, because you might need them help answer questions when the patent office examines it. And in licensing, it can come in mutable number of flavors depending on what's important to you, what's important to the licensor, and what's important to the licensee. And there's really no standard per se. Just I put down here just questions to ask. Is it only for exclusive to only one party, or is it non-exclusive to lots of parties? Early stage technologies I find tend to be, especially startups, usually are exclusive because startups they're taking a lot of development risk. Non-exclusive licensing is often more, there's evidently valuable piece of granted IP that tends to be the way it's done, and everyone needs to get it. Most people not excited about taking non-exclusive licenses. It's more so I won't be sued. Exclusive can actually be an asset because you're the only one who has rights to use the IP. Fields of use is a big deal. My dealing with startups, they always want as many fields of use as possible. Also, if you have lots of fields of use, you can parse it out. But a lot of big deal technologies sometimes, no one startup can utilize it all, and it might be a small piece. But that's also a bit dangerous if you pivot. You pivot it to a different field, and you don't have that field anymore. It's not what you care about. Certainly, territory, the U.S. patent, it also can be defined by sales. If you have international patents, it can be really important. Sublicensing is I'd say that's the way I understand is kind of think like if you have an apartment and say you locked it in at $300 per month back in the 80s in Belltown, and now you're subleasing it to someone for $2,000 a month. Yeah, that's sublicensing basically, except with IP. And that's usually gets very complex. It's often not just about IP rights. It's usually, we see sublicensing, there's development agreements, possibly sales agreements, there's kind of achievement payments. It's a lot of things often mixed together besides just IP rights. And sometimes also there's going to be obligations to, if someone comes who wants it, that you'd be forced to sublicense if you're not using it. Rights to enforce is a big deal. Yes, and also, do you need the license? Do you need the licensor to help you? Usually, if the license has many restrictions, that the licensor will have to be willing to join you in the suit, or if you don't have standing. But sometimes the licensor retains the ability to actually have first right to go do it, like Wharf, University of Wisconsin system manager of IP. That's their model. They never give out this right. They would rather sue it first. University of Washington, happy to let the company go take the first stab at it. Diligence, there may be no diligence, or maybe there's, you have to execute on a plan. Commercial licenses, especially for known valued IP, might also have diligence tied to your sales, like you're going to sell and commercially successful, or it might be more technical. University licenses tend to have diligence for exclusivity to make sure that someone's trying to, utilize and move towards a product for kind of a public good. And also, what cases can you get the license back? Payment, what's your chances to remedy and fix things? And then, of course, the fee. How's that structured? And there's everything from just one-time payment. It could be a ongoing royalty. There are some restrictions, though, also legally that for patent licenses, you can't charge a royalty beyond the patent life. Or the royalty has to be reduced. So that's become a bit of several cases of a case law in that last few years. But things can look in all sorts of. There's so many different ways it can look. Just a little bit that I'm not going to go through all these, but in dealing with universities, in some ways, universities very much they want to be right, sometimes often more than being rich. So definitely there's a big public good aspect that flavors how they do licensing. Whereas if you license for intellectual ventures, I don't think they care. They're pretty happy that, it's probably much more strictly commercial. But the university license people, if we seem like we're somewhat confused and we don't know what we really want, it's because we want 20 different things. We want to make a lot of money, but we also want to do the right thing. And especially a lot of things are federally funded, so there's a strong mandate to try to do things in the public interest, especially where it's exclusive. Just things that if you ever do a university license, this is kind of what they look like. Usually there's an upfront fee of some sort, although for startups, depends on the university. Like University of Washington, if you're doing a startup, you don't usually ask for cash. You probably have enough things to spend your money on rather than giving it to us for a licensing fee. Equity, most universities will take, some don't, but most will take equity in startups. Usually there's some form of anti-dilution tied to raising of investment money. Just because in the early stages, the cap table could be quite unstable with people coming off and on, and also unusual dilution events. But most of them are designed that by the time there's first priced financing, that would stop. Its practice varies, though, but that's pretty common. Royalty on sales, usually that's pretty typical. Royalties, I'd say, for university technologies, almost always less than 5%, unless you have really well-developed software or something. But that's usually well less than 5%. In sublicensing, for if you sublicense it to apportionment of fees, typically between typical industry, you probably see around 20% of 15%, although there's different schemes that start high and drop below that too. Diligence milestones for universities is very, very common. Typically is based on the company's development plan of key milestones they're going to make to actually get there. And also what I find for a lot of, especially university startups, patent expenses is often the biggest challenge for the nascent company, because most University of Washington and most universities probably won't carry the ongoing patent expenses for their startups. That it's something which you can imagine that you're hitting prosecution, that's going to be over the course of a year probably spending $10,000 or $15,000. Or if you're doing filings, there's $10,000, $20,000 each for those for full filing. So those can add up and be something to keep in mind that, especially the very early stage, when to license.
So are you saying that the companies are responsible for those licenses that the universe, that those fees, the university doesn't do it, or is
That's,
it on a case by case basis?
well, practice varies across universities. University of Washington say that that is an absolute thing, that for back patent costs, we'd like to recoup that as far as financially can. That's been spent. It's, you know, we'd like to get money back so we file more patents, but ongoing, there was a time where that was a bit more generous, and it didn't work out too well. And the budgets are, let's say, a bit more tighter. I don't think there's too many universities who will front ongoing costs too far, just because
No.
they accumulate so fast.
Well, they're also expecting that the companies, you know, by giving them this protective agreement here, that they would actually be able to go out and
Yeah, raise some
raise
funds,
some
and
funds on it. Yeah,
so
thank you.
that's often one of the early kind of unavoidable cash expenses of licensing or developing your own IP. It's there's no way to stop it. It's so University of Washington, though. So when I started, let's say a lot of license negotiations, often usually faculty involved, were painful, expensive, and long, and mentally traumatic. So we tried to improve it. And I actually think it's a lot better than so it's called Husky Fast Start. I don't remember what FAST stands for. It stands for something. But the idea was to not make it so horrible, because especially stressful for teams we work with internally that we're trying to help them. And all of a sudden, you know, it's just, we're on opposite sides of the table for, you know, really, you know, stressful experience. It's still somewhat unavoidable, and also is somewhat unpredictable. And, you know, as I say, it's scary because you don't know about your licensing. Most people are not experts on it, and, you know, dealing with people, that's just what they do all the time. So tried to make it predictable and save a lot of the trouble. So this is available. Usually there's some sort of UW founder involved during licenses. But for the terms itself, particularly the royalty, it's comparable based. Most of the other terms are fairly standard across. So we actually have access to a very large database across the country of startup licenses from universities, which I think gives usually start the median value. Like, you know, like, yeah, there's these 15 licenses or nice 50 licenses in the category, and, you know, this is what the data tells us. And you know, if you have data to contribute or something, you know, besides like, I don't want to pay as much, I like smaller numbers, that's not really helpful. But if you have some data, then it's more of a data discussion. And also kind of understanding that, you know, it's implicit deal that in the future, often there is a lot more, because people don't understand their cost basis. They don't understand often what they're necessarily building, the role of the IP, but also, you know, in the future that, you know, this gives data basis to have discussions as people understand what their business is. But usually I find that just to give you rough numbers, don't hold me or anyone at University of Washington to it, but medical devices is typically those comparables probably around 3, maybe a little bit below 3%, often what we see from across peers as a median. Therapeutics, probably around 2% usually. Sometimes research tools, drug discovery tools might be a little higher, but as I said, it's designed to be a conversation. Actually, I really enjoyed it because it allowed me, instead of like thinking like, oh, I need to start high and get whittled down, it's like, you know, here's what I found in my research. You know, someone, you know, somebody asked like, well, what about, I think we're actually this category, and I could actually honestly try to be helpful, see if I can find a better deal, if I could justify it. And that's taken away a lot of the just fear factor that you're gonna, that if the licensing goes quickly, that you get a bad deal. The other part was found that often the same things again and again were negotiated with attorneys in town and conceded regularly. We found that, okay, so if you spend a lot of money getting to where we go anyway. So we just had a big negotiation, I think about a dozen of the more active startup attorneys in town. And they said, what do you want? And if we can give it to you, we just will. And which I think is actually came a very fair deal. And, you know, that, you know, there really is no better deal. Might be slightly different deal if you have unique cases, but that's, I think, made so you don't need to spend a bunch of money negotiating against UW, because a startup has a lot better things to do. So I said that's I think everyone agrees it's made life much more pleasant for everybody. But I say it's a startup, and almost always something will be renegotiated. That's just the nature of it. There is this an implicit promise of trust that we will listen when reality doesn't go as we thought. We make our best guess, and licensing structures may be very flexible for different business models, but you don't know what you don't know. Almost always diligence milestones, the timing, sometimes the activities, those almost always renegotiated. Finance, sometimes, often, like, especially the company's been around longer, sometimes just for just bookkeeping purposes, we change the way the royalty's done. And a couple, I think 2 cases I've been involved, we actually agreed to a buyout where, it really was a fair deal to buy out the royalty, and every stakeholders all agreed. Well, that's pretty rare. Most people don't want to make big upfront cash payments.
How fast is the patent right process at UW right now?
To get a license, you mean, or
No, not to
just to get a patent?
Well, to actually have access to license your patent back, I believe is the question. Is that right, John? Yeah. So if you want to take some of the IP out of the university.
Yeah, I say for most startups, especially those who've been internally incubating, if a UW founder wants to do a startup, that's what we're going to do, unless with their permission we've already agreed to do something else with someone else. One time did come up, like, already did an option agreement and they want to take the license. But so that's part of it. And so generally, take it when you need it. To actually go through the process, if we really tried hard, got things back and forth immediately, get it done less than a month. There's some parts of, like, there's a internal conflicts of interest check that I don't have control of, and that takes usually at least 2 weeks, assuming that all the inventors actually respond to the questions in a timely manner. I'd say I'd budget 3 months just because of the realities. Often you'll send some questions, we'll meet, people look at it, they consult on their end, talk about it, maybe a week goes by. We look at it a couple days later, get back, maybe we have a conversation, just goes quicker, get a draft, make some changes, come back after they've had it for a week or two, with their advisors, or their attorney may looked at it, and depending how complicated the issues are, it may take me a week to get back. So easily you take a couple months. Well, most of the time it's just spent waiting for the other party to get back to you.
Okay. John's comment is that 3 months is an eternity in startup land, but it sounds shorter than a previous university engagement, which was like 9 months. So
yeah, I say it can be done faster if everyone's really agreeable. If people just said, like, oh, okay, I'm just going to trust those terms, which we've had people with attitudes like, I'm just going to trust this is fine, I'll come back later if it's not. That's often then it's the conflict of interest policy that's holding us. Just that, for that to be issued, give the clearance, which is almost always happens. It's just a matter of it being done. And that's just for the university people's own sake, to avoid being caught up in the state ethics law.
Right.
But sometimes we have made things move pretty quick.
Thank you. Thank you. So what happens to the money?
What happens to the money the university gets? So that'd just be some interesting perspective of what we do with it. So I say 20% retained for commotion operations. That does not necessarily always pay for the cost. Say tech transfer offices are fairly expensive, and but of the remaining 80%, so the inventors basically I think it comes out about 26% of the licensing dollars. That's what the distribute among the inventors, and the way they agreed is fair. Usually people are able to make an agreement. Sometimes they agree even shares. That's kind of like the default option. Often they will, like, this person really, they came with a lot of the great ideas. They really shepherded it through, so they deserve more. But our policy, though, if you're an inventor or creator of the IP, you have to get distribution. Sometimes additional people be included, the team wants to, but then they say the departments do get some money, and they like it because it's very flexible spending. and then you have the provost office. Now you probably kind of see there's being split into a lot of different places. So yeah, this is probably not the easiest way to obtain great riches. There are certainly people who've gotten very nice checks. Recent years, actually, we've had equity has been very lucrative because in the biotech sector, there's been a lot of early acquisitions and IPOs. Actually, life sciences in general, there's been a lot of equity. Those are one-time events. They really make a lot of money. You need $1 billion product if you're getting like 2% off sales. That's therapeutics, or maybe something that goes into every cell phone. But that means for that market, you probably need to be suing people. You're going to be forced to infringement probably, unless you build up become a supplier of that thing. But yeah, the math is not tough. Yep.
Hey, Ryan, since you just mentioned equity, I thought maybe I would ask you, since for those who might wind up being an investor in a startup that licensed technology from the university, they may, as they come to look at the cap table, realize that the university will hold a position on the cap table. And could you comment on where that comes into the licensing and what would be typical to expect in terms of equity nowadays in licensing as you've seen it?
Yeah, that's a good question. So for an exclusive license, it's almost like 5%. And that's usually anti-dilution. It kind of depends on the sector. I'd say it's usually between $1 to $2 million of investment raise. After that point, University of Washington become just a common shareholder. And that's just to provide early stage protection at points where sometimes they're disproportionate. Dilution also a way for the university to stay out of the company's business. So we don't need to be policing the cap table, and no one wants us to. One difference though is biotech, just because the deal sizes are become very large for seed rounds or tens of millions. I think that, I don't remember, I think that's might be like 10 million or something. That is an area where the anti-dilution is higher just because the round size is so much higher. Typically, usually by the time the first priced round occur, typically what often we'll see is there'll be some notes, and then there'll be a price round, and that'll all be calculated. And usually before the priced round is, I guess that equity is created and purchased. Usually the university is a common shareholder by that point. If for some reason, if it really was a bona fide honest round and we still have this anti-dilution hanging around, that's a conversation we'll have, because that could be a real problem in a B round, and that's not our intention. So it's purely designed just for the early stages where the equity amount is set, assuming that you're getting financing. A lot of teams aren't ready to get financing. Often, SBIR grants, maybe some friends and family, they'll kind of work through to become really truly investable. And but often they often take the licenses before a significant financing event happens.
Ryan, is there an ability to structure non-voting stock for the university?
Yeah. Oh, actually, the truth is we never vote our shares. We've had some people issue us a special non-voting shares, and that's fine. No, you typically, I don't think we're ever on boards or board observer. I mean, I think we like knowing what's going on, but just the newsletters fine by us. Yeah. But I usually say try to stay out of people's way. But I say there's other institutions that are a bit more hands-on, and there's a select few that do have done things that look like out and out equity investments, but those are usually separated from the university and look like VCs.
If you're not associated with the university, where would you recommend a founder going to get some assistance, or an investor going to understand what the relationship was?
So if there's some relationship with the university, well, of course, start with the founding team. I've often been asked cases where someone's doing some sort of diligence and just wants to, they want to know everything's okay, the company's caught up on their licensing obligations, relationship, and if the company gives us permission, we can speak on that. Or sometimes we do a simple letter saying, it's all fine. So, I mean, you need the permission of the company though to release information.
Okay. And if you were not, like, you're a fantastic mentor for people who are a part of the university scene, but what happens if I'm not part of the university and I need some resources? Where would you get? I put in the chat, the US PTO does a lot of education sessions. That might help you to know how to do some, patent searching and things like that. Where else would you recommend?
That's a challenging one. So if you're like, say, like a University of Washington student and it's not University IP, there's the Entrepreneurial Law Clinic. They also offer means tested services. Beyond that, I'm not sure if there's really great sources of advice. I mean, most attorneys in town, most of them will have an initial chat for an hour just to give you some basic advice. I mean, for legal things are challenging. Ideally, if you could find an advisor who'd be willing to talk to you. I mean, one place that even if you're not a University of Washington startup, that we do welcome other people in the incubator spaces available. So that's, that includes access to a large pool of mentors and advisors. Life Science Washington has a lot of fantastic programs, mentors and advising programs. I'd probably where I would go and get some opinions. Unfortunately, like a lot of the legal questions often lead you to attorneys. And I think main things that choose your attorneys for like the corporate side and the IP side carefully. I find a lot of people tend to talk to the first one, and it's often the most expensive, aggressive law firm in town, and it doesn't work out so well. Whereas should date a little bit. People have conversations to try to find someone who's aligned with you in terms of cost and degree of services offered and philosophy. But yeah, I guess that's gonna help. But legal advice might be a bit more challenging because I think there's concerns about liability and client relationship there.
Mm-hmm. Thank you. Thanks. I want to make sure I'm sensitive to the time and your I don't know how many more slides.
At this point, that's the main part of the talk. So
okay,
probably a good place to end. Most of it was just going to I just show us the reality of tech transfer of this is Stanford's data of three patents that made more than $100 million. So or inventions. But I decided.
That's impressive.
Yeah, that's a great office too. But it's very much of a long tail game. Yeah, that's all I have to share. So.
So I want to make sure that if people have questions that they want to have asked that get answered, Gage or George, John's been putting some of his into the chat here. So.
Oh, okay.
Yeah, I think the one question, where do you find that data on IP to lead to the equity rates at the UW? Do you want to elaborate on that, John? Or did you get it answered?
Sure. No. I'm never quite sure how to track which sectors that UW is actually succeeding at spinning out a piece of IP and turning that into equity and then turning that into a startup. And so when I look at the AUM reports, the numbers are relatively small and they're heavily skewed over to biotech. And so where does UW publish the data around how many patents are filed versus how many get given to outside people versus how much of that turns into equity? That kind of flow question of how research turns into dollars.
Yeah, and there's some on the website, although I think it's a bit more high level than probably what you're looking for. I'd say your impression that seems to be driven by biotech for equity returns is very true these last few years. That's by far outperforming other areas. our website might have the best, although there is the autumn data. All that's that can be hard to parse what you're looking for out of there. I think you might just have to ask us for some of the specific things, because I think we don't quite. I think we do break down startup statistics by sector. I'm not sure if we have broken down returns in that way, though. I mean, we have the information. I'm just not sure if we've really tried to parse that out.
Do we have a notion of what you would expect in terms of, revenue generation for the university, or revenue generation for CoMotion as a 20% of the revenue generated as a budget item kind of thing?
Let's see. That is a known thing. I'd say like licensing. Often just like things like minimum fees tend to drive a lot of like licensing revenue, unless there's a hot product. I'd say that's probably in the order of less than 10 million typically. Equity is much more variable, obviously, but that's been say last few years there's been a lot of good wins on that, and some of it's also structured in a way that as it continues there into success payments for the equity, so there could be more from some of those deals. But the problem with equity often kind of comes and then it's done.
Well, so that's why we have portfolios for angel investors, right?
Yes.
And, if anything, you have a portfolio because you've got lots of people doing this kind of stuff. And if your portfolio is not performing like angel investor portfolios, then that would be an interesting conversation to me.
Yeah. Well, some of it's also different some tech transfer offices are definitely like people like John Hopkins, very bottom line oriented. Some of it also is just there's a strong emphasis on the mission of doing things that are more impact driven. I mean, there have been conversations that have looked like we're like just for like straight licensing revenue, that if that's kind of your goal, that you probably shouldn't file patents, that doing copyright assets actually is much cheaper upfront cost and much longer income streams. Some of those things have some are like direct to end user licenses are actually quite lucrative in terms of revenue. But patents are just challenging just because there's so many upfront costs.
I'm going to make a suggestion here that John, who is interested in economic development of how we're moving our angel community forward, and Ryan, who is now the Assistant Director of Innovation Investments, have a conversation about how to sort of get some of the metrics that help showcase what you're talking about.
Yeah, that'd be great.
I think that might be a great conversation. So I want to be sensitive a little bit that we're kind of coming up to the 10-2. George, did you have any questions that you wanted to ask? I know you're been receiving some mentoring through the Life Sciences Washington. If you're still on, if there's any questions you might want to ask.
No, Ryan and I know each other very well because I'm a mentor at CoMotion.
George is a tremendous help to us.
Yes. Engaged, what about you?
Yeah, I had a quick question. So it seems like a lot of times in the med device industry, you'll get two competing companies, and one was the one that held the original patent, and then there's a royalty agreement there. Are those, in your experience, a lot of times court ordered? That way the other company can provide to the market, or is it usually something that they agreed upon?
So having a counter court order, often I'd say more often probably they've agreed upon it, and they decided they didn't want to litigate it or couldn't be helped, and they came to a deal. We've certainly seen a lot more. I don't know how the sausage is made, but sub-licensing agreed to is much more common than we've seen litigation's somewhat rare. It does happen, but we're intimately involved in it because we have to join the suit for standing. But I think usually it's agreed to, although there might be an implicit threat of litigation.
Good. So what I want to do now is to draw us to a close and summarize a couple of things. Ryan, excellent talk. Thank you very much. And could you tell me whether or not we could make those slides available?
Oh, absolutely. I'll send them to you.
Okay, that would be great. The second thing is that we are next week, same time, talking about business models and with Harold Wadlinger. The third thing is that we're in the process of doing significant due diligence on 5 companies that are part of the Seattle Angel Conference, of which APIS Health Angels is actually modeled after. And the SAC 20 event is on November the 17th, and we'd love to offer complimentary tickets to the event, because you'll see the end product of having looked at these companies for quite a period of time. They went from 85 down to 5, and now it'll be generally a 1 investment, but possibly 2, and some sidecars along with that. I mentioned there are 2 health related companies, one BrainSpace, which is totally intracranial shunt pressure monitoring, and the other, which is a device for cleaning the air in terms of COVID. It's been particularly tested upon. So we have that coming up, and it's November 17th. And if you just save the chat afterwards, you can go in and get yourself a ticket to see those companies present. And I'll be following up with you with just a few emails just to help out, get the word out on that we're looking for companies to come and join us, and we're looking for accredited investors if they want to have a conversation. So thanks for your time, Brian. Once again, delightful that you spent your time presenting to us tonight.
Thank you.
We really appreciate it.
Yeah, well, it's nice to see everyone, and have a good night.